Good morning. I'm Gary DeWaal, and this is Bridging the Week for September 26th to 30th, and today is October 3rd, 2016. Last week, the Commodity Futures Trading Commission brought and resolved its second enforcement action based on the securities industry's concept of insider trading, while a federal court ruled in response to a motion for partial summary judgment that the CFTC must show that a price was intended to be artificial to ultimately prevail in a lawsuit alleging manipulation or attempted manipulation. In addition, the Securities and Exchange Commission agreed to settle an enforcement action with a publicly traded company for terminating a whistleblower where an internal investigation found the whistleblower's complaints were unfounded. I am off to Florida for a friend's wedding over the Columbus Day holiday next week, so I can be timely for my plane. Let's get started. The Commodity Futures Trading Commission brought and settled charges against John Ruggles, a former trader for Delta Airlines, for trading accounts in his wife's name based on his knowledge of trades he anticipated placing for his employer. The CFTC claimed that this was illicitly misappropriated information and based its action in part under a theory equivalent to the securities concept of insider trading. According to the CFTC, Mr. Ruggles frequently placed a trade for an account of his wife and subsequently placed a limit order to liquidate the position at a price not then currently available in the relevant market, but designed to achieve a profit. Mr. Ruggles would then place an order for his employer on the opposite side of the market for the same or greater quantity of the order for his wife's accounts. Either his employer's order would be totally executed against his personal order, or it would induce other traders to trade opposite his personal order. The CFTC said Mr. Ruggles engaged in this and other types of similar illicit trading activity on 71 days from March 2012 through December 2012, achieving a profit of over $3.5 million US. He mostly traded energy products traded on the New York Mercantile Exchange. To resolve the CFTC's charges, Mr. Ruggles agreed to pay a fine of $1.75 million US, disgorge all trading profits on a specified schedule over 42 months, and never again trade on a market overseen by the CFTC. In June 2016, NYMEX brought and settled disciplinary action against Mr. Ruggles based on similar allegations. In connection with a motion for partial summary judgment brought by the Commodity Futures Trading Commission, Donald Wilson and DRW Investments LLC prevailed in their argument to a federal court in New York that the CFTC must prove that they had, quote, the specific intent to affect market prices that did not reflect the legitimate forces of supply and demand, end of quote, in connection with the Commission's enforcement action against the defendants alleging manipulation and attempted manipulation. The CFTC initially filed a lawsuit in 2013 claiming the defendants manipulated and attempted to manipulate the settlement price of the IDEX US dollar 3-month interest rate swap futures contract on numerous occasions in 2011. Defendants generally denied the CFTC's allegations. In November 2015, the CFTC moved for partial summary judgment on its attempted manipulation charge based on, among other matters, the purported quote-unquote undisputed material facts, end of quote, that the respondents, through their conduct, evidenced an intent to affect price. Defendants opposed the CFTC's motion, and their legal views were echoed by 5 industry organizations who appeared as friends of the court, who claimed that the CFTC was applying the wrong standard. They all argued that the CFTC should be required to prove, consistent with prior case law, that the defendants intended to create an artificial price, not solely to affect price, as the CFTC charged. The court rejected the CFTC's view of its legal requirements and rejected both the CFTC's motion for partial summary judgment and the defendant's motion for summary judgment related to this matter. Tom Lindstrom was indicted by a federal grand jury in Chicago and also sued civilly by the Commodity Futures Trading Commission in a federal court in Chicago for hiding trading losses from his employer and causing the firm's financial collapse. According to the CFTC's complaint, Mr. Lindstrom was formerly employed by Rock Capital Markets LLC, a proprietary trading firm where he engaged in trading of options on 10-year U.S. Treasury note futures listed on the Chicago Board of Trade. In order to disguise his trading losses, alleged the CFTC, between January 1st, 2014 and January 27, 2015, Mr. Lindstrom purchased hundreds of thousands of deep out-of-the-money options for a very nominal price. He did this, said the CFTC, to take advantage of a CBOT pricing convention in effect at the time that priced each option for settlement purposes at a minimum of $15.63 per option. As a result, claimed the CFTC, Mr. Lindstrom was able to show his employer that he had millions of dollars of phony profits, that was a quote, end of quote, in his account as opposed to losses. After the CME Group questioned Rock Capital about its large option positions on January 27, 2015, the firm recognized that the purported value of Mr. Lindstrom's account was false by more than $15 million said the CFTC. In fact, the CFTC alleged Mr. Lindstrom had sustained trading losses in excess of $13.9 million over the life of his account, quote, and caused the collapse of Rock Capital, end of quote. And finally, International Game Technology, a publicly traded company, agreed to pay a fine of $500,000 to the Securities Exchange Commission for terminating an employee who raised certain concerns regarding accounting practices with management and filed a complaint on the company's internal whistleblower hotline. According to the SEC, from 2008 through October 30, 2014, while employed at IGT, the employee consistently received very favorable reviews and was promoted to be director of a division with 11 direct reports. In July 2014, the employee raised concern to his two supervisors, including his executive supervisor, regarding how certain costs were accounted for in the company's financial statement. He believed the costs were overstated. According to the SEC, the employee, quote, had a heated disagreement with his executive supervisor on the issue, end of quote. In response, the executive supervisor advised IGT's chief executive officer that he would terminate the employee. However, shortly afterwards, the employee submitted his complaint on IGT's whistleblower hotline. In response, the company conducted a formal investigation utilizing outside counsel that concluded that the firm's accounting practices were appropriate. Following completion of the investigation, the employee was terminated. The SEC charged that the termination violated the employee's anti-retaliation rights for whistleblowing under applicable law. Wow! If an employee is an alleged whistleblower, you can't fire him even if his behavior was bad and his claim was false? Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great 2 weeks, and until the next edition of Bridging the Week, ciao!